It's your turn.
Okay. Thank you everybody for attending. This is kind of odd and awkward for me, only because those of you that know me know that I don't sit still when I speak or I lecture. So I have this propensity to get up and to start pacing. However, that can't happen today. I will probably sneeze and cough a little bit. Trust me, those are allergies. I have been tested and I am negative. So that is strictly what that is. Most of you, actually, there was only one individual that I've seen on the chat box. That is an attorney. The majority of you, of course, are in fact social workers. So I hope I don't bore you because this is equivalent to a 45-minute law school lecture, I suppose. But it is a critical lecture because it is important to understand how the court functions, what the responsibility of the court is, and particularly in today's time with this pandemic. There are a lot of courts, I suspect, that do not quite understand what their roles are when we are dealing with a pandemic and the type of cases that we handle. I will refer, in Oklahoma, these cases are called deprived. We're only 2 states that call it that, so I'll probably use the generic term of a dependency case, okay? Before I begin, I do want to give credit to the National Council of Juvenile Judges. They are, in fact, the creme de la creme, if you will, for judicial training and best practices, as well as the Federal Children's Bureau, okay? We can go to slide 2. The federal laws of the United States is what tells us, all 50 states, of what we must do. And when I say us, that means judges, attorneys, child welfare agencies, okay? Federal law has played a major role in the United States since 1974 in the development of state law and policy. Now, federal laws are basically required to be adopted by all 50 states because if they don't, the federal government, which has many, many dollars, which we call 4E dollars, and that 4E dollar is available to supplement foster care, adoption subsidies, and other programs. If we don't comply with federal law or we don't adopt federal law, the states do not receive this federal funding. And I guarantee that states cannot support foster care, subsidies, and its other programs without federal money. Next slide. This is a list of the key federal legislation starting with 1974. 1974 is the original law that required reporting of child abuse and neglect. And at that time, the primary reporters were physicians and those in the medical field. I will only discuss a handful of legislation that is relevant to my discussion with you today. The first one is the 1980 Adoption Assistance and Child Welfare Act. Prior to this law becoming effective, judges in the courts did very little in these dependency cases. Basically, the judge was required to adjudicate or determine whether or not the child was abused or neglected. The judge then determined whether or not the child should be placed outside of the home, and then the judge was done. sole control of the well-being of the child, and the work with the family relied solely on the child welfare agencies. This act stopped that. This act required court oversight by means of conducting review hearings to ensure that the child welfare agencies were making reasonable efforts to avoid unnecessary removals of children from their homes and to reunify these children with their families whenever possible. Reasonable efforts is not defined in Oklahoma, but the federal government provided a definition, which is to provide parents with useful resources that enable them to protect the child, to provide a stable home environment, and promote the child's well-being. So this act required the courts and the child welfare agency to become simultaneously involved when working with our families. In where is it? Go to the next page, slide. Nope, I cannot believe it's not on there. Anyway, in 1997, the most famous act, and that we are all working under today, is the Adoption and Safe Families Act, better known as ASFA. You can move back to the previous slide. Okay. Oh, there it is. Sorry, 1997, ASFA. This act changed everything. When I first became a judge in juvenile court, we were still working under the 1980 Act. So what that meant is that the department social workers were providing reasonable efforts for years and years and years. Kids were going through foster care drift. Relatives were not recognized as being appropriate placements under the theory that the apple doesn't fall far from the tree. And the cases were lingering and children were suffering. This act's focus was to remedy those chronic problems with the foster care system and to establish not that reunification is the #1 goal, but the child's health and safety was the paramount concern. It emphasized timely decision-making, and this act made the court or the judge the case manager and the overseer of the entire child welfare system. It required that before a child could be removed, that a hearing be conducted for the court to determine whether or not removal or for the child to stay at home was contrary to the welfare of the child. It required reasonable efforts to prevent removal. And if reasonable efforts were found by the court not to have been accomplished to prevent removal, then that child would not be subsidized with federal money for his or her stay in foster care for the entire length of the case. It set up what we call aggravated circumstances, where reunification did not have to be the goal under very serious conditions, such as death of a child, sexual abuse of a child, serious physical injury, torture, abandoned infant. If the court found that those circumstances existed, then the court was required within 60 days, pursuant to a hearing, to determine what the permanent home or plan for the child should be. It also set up a requirement, and it was a brand new hearing back then, which was called a permanency hearing. This hearing was to occur and is to occur within 12 months of the child's removal. The purpose of this hearing since most cases were focused on reunification as a matter of law, was to determine at the end of 12 months whether or not reunification still remained the permanency plan for the child. And if not, then what should the plan be? Which oftentimes, if conditions that cause the child to go into foster care were not corrected, would result in termination of parental rights. The law also set up a very strict timeline that if a child had been in foster care for 15 out of 22 months, the state was absolutely required to file a motion to terminate or a petition to terminate the parental rights of those parents of the child, okay? 15 out of 22 months. Several states, including Oklahoma, reduced that time from 15 out of 22 months to 6 out of 12 months for those children under the age of 4. Not a lot of time. But the purpose, again, was to get children into family homes and to prevent a child from living his or her life in foster care. Judges also were required to document their decisions, why they made those decisions, which we still have problems with. They were required to approve the case plans submitted for purposes of assisting the families. Case plans were required to be developed within 60 days after the child's removal. It required placement to be close to the home of the parents, and it created permanency plans in the orders of priority, that being first and foremost reunification, secondly adoption, third guardianship, fourth, which we don't have in Oklahoma but many states do, custody to a relative, and last, another planned permanent living arrangement, which in essence is long-term foster care. And the department is, of course, required to document compelling reasons why this last category is the most appropriate. The United States policy is not fond of congregate care, and we have a new law that basically eliminates it. Next slide, please. The next act is 2008, Fostering Connections to Success and Increasing Adoptions Act. The only thing I want to mention about that that's relevant to my discussion is that it does require siblings to be placed together unless it is contrary to the safety of any of the siblings. And if siblings are separated, the Child Welfare Agency is required to make reasonable efforts that these siblings have frequent contact. Next slide, please. The newest law is the 2019 Family First Prevention Services Act. Most states have enacted it. Oklahoma has not. I suspect it will next year because there is a time limitation in which it must enact this law. The relevant aspect that I want to talk about or briefly mention is that federal money under this law now provides 12 months of funds for 3 areas of treatment: mental health, drug treatment, and in-home parent skill-based programs. This law puts money into prevention programs. It is available for parents, relatives, adoptive parents, and youth in foster care who are pregnant or already parents. In order to be a candidate to receive this funding, the child must be a candidate for foster care. And what that means is without these programs being placed or being provided, the child would have to be removed from the home and placed in foster care. Clearly, the pendulum has swung back from ASFA, which some feel is rather draconian, to trying to keep children out of foster care and to provide direct services to the family in their home. It is intended also to prevent the disruption of adoptive families, which we have seen and do see, as well as guardianships. The impact of Families First is that the reasonable efforts to prevent removal now becomes critical and will be reviewed by the courts with a pretty strict eye. Okay, next. Okay, so judicial oversight, big picture. What is the juvenile or the dependency court's job in a nutshell? The job is to ensure that every child that should be in care is in care and not a single child more. And to ensure that every child that is in care is in a safe, nurturing placement that is supportive of the permanency plan as announced by the court. Next. So the role of a dependency court judge, and as discussed about the 1980 law, does a juvenile judge just decide cases as they do in civil and criminal cases? No. They have to do much more than decide cases. As I said, the federal law created a system in which the juvenile court judge oversaw the entire case process, including oversight over child welfare agencies' responsibilities. They cannot be allowed to relinquish their oversight as they do in criminal cases, for example. Once a defendant is sentenced, then the court is done and custody and oversight of that defendant is normally given to the Department of Corrections or to a probation officer. This is not the situation in our country. The juvenile court is the original problem-solving court, and several social workers, I suppose, Department of Mental Health certainly has heard me talk or express my own personal opinions that I'm not a big person with specialty dockets, although they are good practice and hopefully it's good training. The reason being is the juvenile court is the original therapeutic court, way before drug courts, mental health courts, etc. Juvenile court was created to be a therapeutic court. And the judge is required to connect with all child welfare system stakeholders and the community to ensure that the needs and of the children and families before the court are taken care of. Why is this the role of the judge? Because as we know in our country, the child welfare system is a tremendously complex grouping of stakeholders. We have mental health providers, we have drug treatment providers, we have reporters, we have schools, we have law enforcement, social workers, government, family members, guardian ad litems, and tribes. So the judge is in a position to observe the operation of each of these stakeholders and to observe the interaction between them. And this allows the judge to identify resource needs across the system, identify gaps in services, and monitor the efficiencies or non-efficiencies of the child welfare system. Next. So the responsibilities, once again, we are, so to speak, the parents of the child, the parens patriae. We are the gatekeepers. We determine which children come into custody and which children leave custody. We do play the typical role of a jurist, determining the facts and the law. We administrate due process to ensure that all participants and parties are provided with due process, that being, of course, appropriate notice of hearings and the opportunity to participate in a hearing. It's critical. We are the inquiring magistrate of the well-being, safety, and the plans, permanency plans for the child. And we monitor all these services that are provided by whatever agency, being that a state agency or a community agency. We set the standards at which the juvenile system is governed, and we're required to provide leadership to the community and all participants of the juvenile court, which is probably why my staff decided that I was bossy. Little did they know it was leadership. So ultimately, the judge is responsible and oversees everything all about the child. And although the child welfare agency is required to care for the child that's in its custody, the court has to oversee and ensure that the child is safe and well cared for. Next. The courts do remain actively involved over a period of time in this litigation. It's not a one-time decision. It's a series of steps that ultimately determines the safe permanent placement of the child. And all of our decisions are interrelated: the removal, the placement, visitation, services, termination, adoption. And the court is the primary influencer of the parent participation and involvement in services. And the court impacts the future of the case by ordering and challenging all the participants who appear before it to expedite the permanency. The court, through reviews, ensures that all steps required and ordered are being taken by the child welfare agency. This is the reasonable efforts requirement. So ultimately, the bottom line is that the ultimate resolution of these cases falls squarely on the shoulders of the judge. Next. So who monitors the child welfare system in the United States and ensures that federal laws and policies are being adhered to? That would be the Children's Bureau via the Administration of Children, Youth, and Families via the Federal Department of Health and Human Services. The Health and Human Services is a cabinet level executive branch of the U.S. federal government whose goal is to protect the health of all Americans and provide essential human services. Next. The Administration for Children and Families is headed up, and again, it's a department of the Health and Human Services, by a commissioner and a deputy commissioner. It did have a budget, I'm not sure what it is this year, of approximately $49 billion for 60 programs that target children, youth, and families. These programs include assistance to the welfare, child support, adoption assistance, foster care, child care, and child abuse. It has control over the budget and the policy initiatives, and it is the main federal funding source for child welfare activities in this country. The Children's Bureau is an office of the Administration of Children and Families, which advises the administration on matters related to child welfare, including child abuse and neglect, protective services, family preservation, adoption, foster care, and independent living for foster care youth. This bureau recommends legislative and budgetary proposals. Basically, they lobby for the laws that we work under currently. It is the operational planning system of objectives and initiatives. It provides evaluations, research, and demonstration activities. It's currently headed up by Jerry Milner. And when Jerry Milner speaks, we all listen. And why? Because this is the division that is the controller, if you will, of our precious 4E money that pays for foster care, adoption subsidies, and very needed programs that the states by themselves cannot afford to financially support. Next. So let's pull in this pandemic or a pandemic such as this coronavirus into this mix of child welfare laws, child welfare courts, and governmental policy and oversight. When this virus swept into the United States, governors and mayors, and our president, such as he is, issued orders that shut down non-essential businesses and required people to essentially stay at home except for very limited purposes. And how did our courts nationwide react? Most of them shut down their buildings. They continued the hearings and the trials. Next. This, our Supreme Court and our Oklahoma Court of Criminal Appeals issued its emergency joint orders regarding COVID-19 and how the courts in Oklahoma would react. Next. So basically what the Chief Justice says, subject only to constitutional limitations, we're suspending everything through May 15th, okay? All courthouses in 77 counties are closed with exception to emergencies as determined by a local order. And if they had to come into the courthouse, then of course no more than 10 persons, including court personnel, could be in a courtroom at one time. As far as any motions or legal pleadings, the judges were directed to use email, fax, and drop boxes for acceptance of written materials, particularly in emergencies. Next. So I guess everything shut down. In Tulsa, at least, as much as I'm aware of it, which is not a lot, my understanding is that the emergency removal hearings, emergency custody hearings, were continuing telephonically. Some cases were handled telephonically, but basically much of the court proceedings were put on hold. I had many courts, including ours, no longer permitted in-person visitations to occur between the foster children and their biological families. A few critical hearings are conducted telephonically or by video conferencing. Reviews and permanency hearings were continued for over 30 days, and in some states, my understanding, even longer. So basically, child welfare cases were put on hold with very little or no action taken by the courts or attorneys to move these cases along by alternative means. Compliance with case plans became very difficult for many parents, as you can expect. And although it is recognized nationwide that social service agencies are doing their best to continue services by means of video conferencing, that may not be that effective. But of course, not all agencies are able to do this. Considering the number of parents who live in poverty, the question becomes how many of these parents have access to computers and Wi-Fi. So families are placed in limbo, and participants within the child welfare system nationwide have expressed their frustrations. Parents who were being prepared to have their children return home are now being told this cannot occur. Potential adoptive parents could not have contact with their potential adoptive child. Siblings who were separated are not able to see each other, and many treatment programs are either not being held or being delivered scattershot with questionable effectiveness. Phone visitations between parents with an infant or toddler has been more frustrating than gratifying. So the timeline set out by federal law, the 15 out of 22 months, the 12 months for a permanency determination, doesn't stop. The limited time for reunification is still ticking. including those for infants, 6 months. Next, oh, no, not next slide. So on March 27th, you see part of the memo. Commissioner Milner issued a letter to all child welfare lawyers and judges in the United States in response to the questions of whether required hearings and statutory findings can be waived in light of this pandemic and the shelter-at-home orders of local governments. His simple answer was no. No. Court hearings and judicial findings cannot be waived or continued. The cases must continue to move forward as required by federal and state laws. He reminds the state judicial leaders that failure to do so will result in the loss of that precious 4E foster care maintenance payments for either the duration of the foster care episode or in some instances until the judicial findings are made. The court must determine at the first proceeding whether or not the home is contrary. That is occurring. The court must, within 60 days of removal, determine whether reasonable efforts were made by the state to prevent the removal. I believe most states are doing that. The court must, within 12 months of a child entering foster care, determine after a hearing whether reasonable efforts to finalize the permanency plan were made. As my understanding, many of these hearings have been continued beyond the 12 months. The court should continue to timely conduct the review and permanency hearings, which are required by law to occur at least and no later than once every 6 months. Mr. Milner notes in his memo that a prolonged or indefinite delay in delivering services and the continuances of judicial oversight places our children's safety and well-being in jeopardy, as well as leading to unnecessary lengthy stays in foster care. He further advises lawyers that parents and children should continue to be able to meet, speak, and stay in frequent communication with their attorneys. And attorneys should be allowed to bring critical matters to the court's attention, as well as to all other parties. In other words, these cases must move forward, and all parties and agencies are required to determine how to get this done safely, but without destroying our families. Next. That looks funny. Okay. Mr. Milner ordered the following for the courts to do. Refrain from making sweeping blanket orders, ceasing, suspending, or postponing court hearings. Ensure that important decisions as to when and how hearings are conducted are made not in an overall order, but on a case-by-case basis in accordance with the facts of each case. He urges attorneys to file written motions of immediate concern, for the courts to make maximum use of technology to ensure due process when in-person hearings are not possible or appropriate. And when, as I said, due process requires all parties to participate in those hearings. So that means providing all parties, parents and children, with the ability to participate in technological hearings. And to assure attorneys to not wait until the next court hearing, but try to enter into agreed to orders so that the case can proceed to move forward. Next slide. In response to the curtailed visitation, or as we call it now, family time, he notes that to suspend visitation is contrary, in most cases, to the well-being and best interests of the children, and may, in fact, contribute to additional child trauma and impedes the likelihood of reunification. So again, he discourages or refrains for the courts issuing a blanket order that reduces or suspends visitation. To be mindful of the need for continued family contact, that to cease or interrupt family time can be traumatic for children, that courts should continue to hold the Child Welfare Agency accountable reasonable efforts for reunification to ensure meaningful, frequent family time. To become familiar in ways in which in-person visitation could continue to be held safely. Consider the use of family members to supervise the contact, and to consider engaging with visitation outdoors when feasible. Ensure that parents and foster parents have access to cell phones and computers with internet access. Ask the parents how visitation should proceed. Some parents may very well prefer to use technology due to health concerns. And for the courts to consider whether children may be reunified with their parents in an expedited manner if the child's safety will not be jeopardized. Next. And lastly, he notes that child welfare agencies should take all measures possible to continue to ensure that parents and children receive their services and treatment. Interruptions of services and treatment due to lack of provider availability during this pandemic will present significant barriers for parents working towards reunification with their children. The lack of participation in cases in which services cannot or are not being provided should not be interpreted as a lack of parental compliance, therefore leading to termination of parental rights. He suggests that this lack of services or resources may indicate an agency's failure to make reasonable efforts to reunify. It's pretty strong language, very strong language. I would suggest that this would be a compelling reason not to file a termination of parental rights merely because a child has been in foster care for 15 months. Next. So, in addition to my previous discussion of the court's oversight, it expands during pandemics, okay? The judge is required to ensure that hearings occur in a safe manner and that required judicial findings are made. The judge has to ensure that due process to all parties by providing adequate notice of hearings and the manner in which these hearings are to occur. The court should ensure that attorneys and the parties are, in fact, continuing meaningful communications with their clients. They must ensure that visitations are occurring in a meaningful manner. The court should inquire about and monitor closely of the availability of treatment and other services for parents and children. And they should ensure that the Child Welfare Agency is making reasonable efforts to assist parents in meeting their goals. Next slide, please. And to expedite trial reunification and provide remote training to attorneys on how best to use technological platforms with their clients. I put this assurance wireless because I just discovered that the federal government has a program for eligible low-income individuals to receive a free phone, free monthly data, unlimited texting, and free minutes, which may continue to be critical. So I urge anybody from the Department of Human Services or attorneys or whatever, this is how you contact them. I was pretty excited to read that. I had no idea. Next. So looking ahead, future issues that are going to face the child welfare system. First question is mortality, whether the child has lost one or both of their parents. I just read an article in today's paper of the Department of Mental Health Commissioner being very, very concerned about the increase of alcoholism, suicide, and drug abuse due to the isolation. The economic impact on our already poverty-stricken families. We know that the child abuse and neglect rates will rise. We know that. Oklahoma has, approximately 50% reduced reports of child abuse. We understand why, because these children have been held again in isolation. We don't have teachers, the typical reporters who come in contact with these children. So after this is done, we will see a shift upward in the number of out-of-home care, which is pretty common in our history for any social calamity. Will there be enough preventive services? We have that new federal law requiring preventive services. So if we don't, does this mean we're going to need a lot more foster homes? Will we be lacking in services for this much with a lack of respirators for the virus? This is going to be, my internet connection is unstable. Okay, let me know. There'll be a tremendous stress on our workforce. It's going to be very difficult for child welfare workers to make those hard decisions about who gets the service, who doesn't. The burnout, the worker retention rates, the difficulty in recruiting new workers. So our child welfare social workers definitely will need more support with decision-making guidelines and resources for children and their parents. And we need to be mindful of the social worker's own need for their own first aid. Next. So our kids in foster care and our families are already socially distanced, are they not, from each other. As I have discussed, this pandemic or any future pandemic cannot set aside the judge's obligations to protect family integrity. That family integrity is guaranteed by the United States Constitution. We cannot forget the simple fact that most children miss their parents and most parents miss their children. And that absent aggravated circumstances, they deserve a fair shot to be together or to get back together as soon as it is safely possible. Coronavirus cannot allow the courts to hit the pause button. This is not only the harmful threat of the virus, but there's a harmful threat when we interrupt a parent and child's relationship. The federal policymakers have made it very clear that the public health crisis does not grant to any of us permission to forego making reasonable efforts to keep families together, to reunite them as quickly as possible. So therefore, we must be creative in making those efforts. Time is the biggest challenge that law or the Adoption Safe Families Act places on us. As I said, the clock keeps ticking. And the aftermath of the health crisis will cause us to continue to deal in the manner in which this virus has affected the child welfare systems. We have to be proactive in finding solutions and not repeat the mistakes of the past, although sometimes well-intended but deeply misguided in the name of helping children. This is a picture of the orphan trade. Someone noted they wanted to know how I got that title. This was a supervised child welfare program by well-intended social workers that transported orphaned and homeless children from the crowded eastern cities of the United States to foster homes located largely in the rural areas of the Midwest of our country. The East Coast, for those historians might recall this, was in the midst of the industrial areas, where because of the poverty in the big cities, both parents were required to work in order to survive, and children were left to fend for themselves. It's also the time when the Irish immigrants flooded the eastern cities, and strong feelings of discrimination were taken against them, as well as Catholics. So children removed from their parents regularly, they were placed in almshouses, which also became overpopulated. These orphan trains operated from the mid-1800s to the early 1900s, and they relocated approximately 200,000 orphaned, abandoned, abused, and homeless children. Many of these children were used for slave laborers. Others did very, very well. But families were destroyed in the name of helping these poverty-stricken or incorrigible children. So the point is, we must be careful. We must take innovative and appropriate actions, as suggested by Commissioner Milner, so that this pandemic or any pandemic will not serve as the modern day train that results in the redistribution of other people's children. Questions? Look at all those faces.
Thank you so much. I need to take a breath, I must say. It wasn't easy, yeah. Thinking about all of these families that are not able to see each other, and visitation is impossible right now. It's also an issue, I know, in Israel. Okay, Christina, and please take a few seconds to write the questions. And as always, our wonderful Christina is going to moderate this. Christina, are you with us?
I am. Can you hear me?
Yeah, we hear you now.
Awesome.
Thank you. I hate lecturing, and sometimes it drives people crazy. I lectured in Washington not long ago, and it was primarily social workers, and they said, why do we need to know the law? Why do we even care? It's because the law in the United States is why we are here. And it is important to understand the importance and the support actually and realistically needed to be given to a judge who may not be that well informed as he or she should be, okay? The second critical aspect of it is our federal law does not allow us to sit back. We are first responders. We are no different than police officers. We are an emergency room, are we not? We are all part of the treatment. And if families ever needed help more, it's now. Just because the courthouse is locked does not mean that the judges have a break. They shouldn't be. It doesn't mean lawyers have a break. And certainly doesn't mean that all of us who are here to help families have a break. So we have to figure out how to get that done. I know states are opening up. I know that there are a lot of questions about that. I hope there is not an uptick, but we have no idea what the future holds. So I suspect the way we've been functioning will continue. However, we need to be more aware of what we should be doing to promote reunification and to ensure that a child doesn't stay in foster care a day longer than he or she has to. So those of you in child protection, what is your experience with the courts? That's a good question because I have no idea.
We also have some information from Donna. She says, I am a panel attorney and represent parents in CINA and TPR cases. Our courts are closed now until June 5th. All necessary emergencies are being addressed through social media and the phone.
What about visitation, family time? What's going on with that? Nobody knows? Jerry Milner set this, actually he set out 3 memos. The second one was called Child Welfare Directors in all 50 states, advising everyone as far as how to access technology, how to get their parents and foster parents free phones, how to get free Wi-Fi or internet connections. Hopefully that has trickled down to provide assistance. The third memo he sent out were to all state Supreme Court justices, basically advising them of what I discussed today. Whether or not they're listening to him, I don't know. I don't know. But it is a shame.
We have some questions for you, Judge Francine. We also have some "I'm sad you retired" comments, and thank you, and we admire judges for what they do. Just wanted to make sure you got those messages. So the question is, during this pandemic, we've seen an outpouring of support for first responders in healthcare and the grocery industry. How can we frame these services and the courts using similar scaffolding?
How can we frame the services and what?
It says, how can we frame these services and the courts using similar scaffolding?
Of course, I've always said we need an outpouring of support for our CPS and child welfare workers. You know, firemen and police officers get big medals and recognitions and their faces on the front pages of newspapers, et cetera, for heroic deeds. And yet we don't do that for our first responders in child welfare. The courts need to, in a leadership skill, sit down with the participants, whether it's by Zoom or telephonically or whatever, and figure out and work together, collaborate on how we can support our CPS workers and child welfare workers. We have those requirements to ensure the family time and visitations occur, but we also have the requirement to ensure the health and safety of those that work with us in the child welfare system. So it is critical to sit down and brainstorm of how are we going to do this in these very, very difficult times. The National Council requires the court to take the leadership of setting up those collaborations and discussions, and that is probably a critical one that should be occurring now, not only in Tulsa, but statewide, nationwide.
Thank you for that. So we had some people answer your question about visitation. They said family time is being done via FaceTime or video chats. Current foster caregiver. Our caseworker told us all in-person meetings are on hold until further notice. We use FaceTime to connect the kiddos and their parents. DSS is conducting visitations through Skype, iPhones, etc. AT&T are doing $10 a month Wi-Fi for low-income families. Family time is occurring in Tulsa via video and phone. It is painful to see them ache for physical contact. However, it's occurring. Okay. And then there's another question for you at the end of those. CASA Advocate has a question. With the probable uptick of cases, do you see a push for additional funding for the additional services that are going to be needed, foster home recruitment, etc., happening at the state or the federal level?
Seriously doubt that's going to happen at the state level, right? I mean, they're talking about slashing budgets, agency budgets. So I seriously doubt that. The federal level, it's potentially might happen. The federal funding for prevention services, i.e. the mental health drug treatment in-home services. I don't know how much money, and certainly all 50 states will be fighting with each other to get a piece of that pot. I hope that and suspect maybe that there may be some additional funding, but I don't know. Our DHS leaders would have a better idea of that, but statewide, no, I wouldn't hold my breath. And in these economic times of recession, I suspect most states will have that issue. With respect to visitation, and you'll have to email me your email, and I didn't put it on this, and I wish I had. Who was it? Anyway, through all this federal information, I found an outstanding recommendations as to family time based on the developmental age of a child for telephone or video conferencing or whatever. How the frequency, what should occur. You know, babies are going to have a hard time understanding what a phone is or iChat. But anyway, it is a fabulous resource, fabulous, some really good ideas in there. So I'll be glad to send that to anybody who's interested.
Judge Fransein, if you hand that over to Gal, then we'll be able to distribute it to everybody that came today and registered.
Will do, will do.
Awesome, thank you. We have another question. So without funding or additional funding for services, can reasonable efforts still be enforced?
Yes, yes. This isn't anything new. If you talk to any child welfare worker or a rural judge who lives in a rural area, they will get very frustrated and say, what do you expect us to do? We don't have the resources Oklahoma County has. We don't have the resources Tulsa County has. Nobody really has a lot of resources, particularly in rural areas, but the federal government and the state law makes it very clear that reasonable efforts still have to be provided. Sometimes those resources are provided by an excellent child welfare worker themselves. I have tremendous respect for child welfare social workers that reside in rural counties. They do a lot of work themselves. The second thing is if we don't have those resources, this reasonable efforts finding goes to the Department of Human Services. So it's really up to the department to figure out how to balance those resources and to ensure that there are resources provided to those families. It will be difficult, but no, it will not excuse reasonable efforts, ever, ever.
I think we're done. Thank you, Judge Fransein. Thank you so much for your time.
It's
and
good
for
to see those of you that I haven't seen in a while.
And you can take a moment and look at the chat while Christina is giving her information about the CEUs. Thank you so much for this important morning. Thank you, and stay safe.
Take care, you too.